Good afternoon. How are you today? Well, the temperature is not bad, but I have no sun and the wind is up. And it makes it's not a dramatic difference, it makes a difference. So we hanker after the warmth, which is just around the corner. And then we can complain about the heat. Humans, never to be satisfied. Tantalized by one and then the other. That is reaching up and pulling away, and reaching down and pulling away. So, what is of interest? Well, what's of interest to me, and sort of busman's holiday, I heard only a portion of the hearing down in Georgia in the case brought by D.A. Willis against Trump and others. And the story is the ongoing hearing of whether or not Willis, the DA, and Wade, her principal assistant on the case, were having a relationship, and there was some sort of favor that went back to Willis after the appointment of Wade. Now, it seems to me that this probably fits into another episode of disinformation. I'll tell you why. There are two things that have become important to establish. One is that they had a relationship, an intimate, romantic, or sexual relationship before Wade was appointed, and Wade gave her funds in the sense of trips that reflected, in the worst characterization by the defense, as a payoff for getting the job. Now, let's go backwards a little bit here. Let's assume there is a relationship, and there was one. The question is, when was it? That relationship, it is very likely in any relationship that a man or a woman could spend money on trips or hotels or dinners and things like that. But isn't a kickback, you give me cash or a check? I don't expect favors. Do I want to go to an island with my mother and Wade if it's about the relationship, but not if it's a payoff? Because I'd rather receive cash than have a trip. And Wade is the guy who likes to travel. So there's that. And here's the thing. They both, Willis and Wade, testified that she paid her own way. And she paid in cash. And there's nothing to contradict that. Okay, so when did the relationship begin? They say the romantic relationship, the intimate relationship, did not begin until after Wade was on the job and appointed to the position after March of 2022. But they knew each other for some time. He helped during her campaign. He had a lot of phone calls with her during the campaign. He, Wade, with Willis. And they may have had dinner and so forth, but they were not intimate sexually. Now, at the hearing today, they had on the stand Wade's counsel in his divorce case. And if you remember, Wade's wife apparently was having a relationship with someone else, and that's what broke up their relationship, and they were basically separate and apart, though not legally yet separate and apart because of the pending divorce case. And so she had her counsel, which apparently cooperated with Trump, and he had his counsel, who was a friend and a member of the law firm. So you have his law partner on the stand today. And the question goes like this. The question is, I understand that the defense counsel in this case, that is the case prosecuting Trump and others, that the defense counsel had an exchange of emails with McArdle, who was Wade's attorney, and apparently he gave some indication of knowledge of a relationship between Willis and Wade. But it appears two things. One is that what he said in a text message or email going back and forth was speculation. Now, if you saw two people together a lot and you saw them talking about the campaign and these things, could you say they had a romantic relationship? Well, probably not, but people might speculate. So I think that's the category of information that he today said was what he considered the exchange with Merchant, who was counsel for one of the Trump co-defendants. So that's the lay of the land. Now, the motion that Merchant brought was to disqualify from prosecuting the case Willis and Wade, hoping that by this they could end the entire prosecution. But there's a couple of flies in the ointment. In order to carry the burden of proof, the defense has to show, one, and they've said this for themselves, that they had an intimate relationship before March of 22, when Wade joined the forces for this RICO prosecution. And to date, including today, as far as I can tell, they haven't proved that. Secondly, they have to prove that the funds for these trips were, in some clumsy fashion or other, a payoff for having been appointed. Now, I don't know these two people other than what everybody else sees of them, and I have heard some of the hearings, so I have a better taste of this particular hearing than some others. So, if I look at this, I say, so what? And I think it means that if the judge sees the facts as I do, the judge would dismiss the motion to disqualify and let them both remain. Now, there have been, out of the eye of the public, some exchanges with the judge. So he may have some additional information that we don't know about that will compel him to act in some way or other. But until that is disclosed to the public, I would say they don't have a very good chance of disqualifying either Willis or Wade. Now, I have another observation which sort of made me angry at the proceeding, and it is seeing bad lawyer work. And it goes like this. There are a bunch of defendants, and each has a lawyer, and when you have a witness on the stand, everybody who's in the case could get up and say, I want to ask a question. Now, that's not the way to do it. The way to do it is if everybody feels they have to be involved. You can't have them all get up and talk about the same material. So you might choose one or two lawyers to do the whole thing to make it more punchy and effective. Well, because this is being televised, these guys want to preen before the cameras. Okay, and we'll talk about their performance in a minute. Another way to do it is to chop up the examination of McArdle into what a good friend of mine, Posner, calls chapters, and have different people handle chapters of the examination. So then you don't get in a situation of annoying the judge because you're going over the same material that lawyer 3 did, that lawyer 2 did, that lawyer 1 did. So there's that. Now the next thing is It's infuriating. Not only do they not organize the case to do this in a professional way, which suggests that maybe they don't do much homework at all about how to do this. A good cross takes preparation. And to simplify it, it is a question of controlling the witness so you can ask him about things that you can't yet prove. And those last questions, for that reason, sometimes you don't ask. So, for example, you say, isn't it a fact that you, Mr. Wade, and Willis were sexually involved? Period. End of question. He has to say yes. He may say when. I said, no, I'm just asking you, did you have sexual relationship? Please answer the question. Your Honor, will you direct the witness to answer the question? You had sexual relations with this woman. Do you hear Clinton in your memory? So you ask the question that way. You control him. He knows that you know that. You said on direct that you, or cross, or whenever, you said that you had lots of phone calls with Miss Willis. Isn't that right? Isn't that a fact? Yes. You had many of them. You can't even tell us how many that you had. Isn't that right? Oh, yeah. And so almost every day, isn't it a fact you talk to her? Yes. And you realize that when you talk to someone on a phone, that information as to where you are when you're on that phone is memorialized electronically and can be pulled up, brought to this courtroom, and we can ask you about individual calls. You know that. Isn't that a fact? Right. Isn't it a fact that you made a phone call from her apartment? Yes or no? Yes. Leave that there. So, but they don't do that. They don't ask questions that way. And I'm not as familiar with the case as a good lawyer should be. But those are kind of obvious questions you can ask. And, you might also say a different lawyer would have questions about the funds. Have you ever in your life taken other women on trips and paid for it all? Yes or no, Mr. Wade? Now, that's a dangerous question, because maybe he has. Okay, that would hurt the defense. Maybe he has. Maybe he got favors in other instances because of it. You can see how the lack of discipline can get you as an advocate in a difficult position. So the question about the funds is, if you're on Willis's side, you might ask the witness that, as a Southern gentleman, are you in the habit of picking up the expenses for a dinner or a trip or something like that? Isn't that right? Yes. Now, you probably don't want to ask questions about bribery and gratuities, but if that came up, because that's really what the defense is saying, and then you would say, when people give gratuities, is it trips? And the answer is, we've had a couple of Congress people in which trips were the answer. So how do you get around questions about the fact that she paid for it? Well, she had her dad there talking about why cash, because even when he, her father, who's a former Black Panther, even when he tried to pay for a meal in Massachusetts, they wouldn't recognize his cards. And so he had to pay in cash, and that's where the rule came for him. Powerful testimony. They should have been smart enough to keep it out. They didn't. They thought he was just a comfortable older man, I guess. They didn't really know who he was, what they could do with him. And they did some low-hanging fruit, amateur bullshit. And it didn't work. And then the judge is in the position of continuously telling him, well, you asked that question and you answered it. So what we had is a flawed theory for disqualifying Willis and Wade. We do not have proof when they became a romantic relationship, no more than we would of anybody else that we just saw together. We wouldn't know unless, well, you were in the room, or you taped it, or you saw him go in the evening and come out in the morning. None of that evidence from anyone. And the most they have is an employee who was fired, who at one time was a friend of Willis, saying she saw them kissing. Nobody else has seen these two kissing, not even since they had a relationship. So how credible is it if they were being private and personal in their relationship that this former employee had seen that? At least it's a credibility question. And then the lawyers, they should be fired for impersonating real criminal defense lawyers, because the tools to use the questioning techniques that I talk about, I don't know that it would have changed anything, but it would have been professional. It would have shown these advocates to be up to the mark of this sensational and historic trial. But they couldn't do that. They're hungry in their amateur pursuit. And what they do is, and I don't know why there aren't objections. I'm a firm believer you should make objections, because then judges say things like, oh, you waived it, you let them ask that. So when they start saying, they don't say isn't it a fact. What they say is, they give a long paragraph, which is objectionable because it's compound, makes lots of statements, not just one. And it's really a speech because there's not even the inflection of a question in it. So it shouldn't surprise anyone that the lawyers recruited by Trump are not impressive, including Trump's lawyer, whom some commentators thought had done a good job. And I thought he didn't do a good job. And that what he really did was, of the 5 questions he asked, at least 2 of them were just statements. And then when he finished, and there's not a jury present, he goes, oh yeah, something like that. Like he's stung by how unfair the judge is. The judge is going to decide this. That's not a smart thing to do. So I only discussed this one matter today because sometimes we should drill down on this stuff so that we understand that Trump is really only interested in throwing sand in a mimeograph machine. Please forgive the historic reference. And because it reminds me of Columbia during the riots. And that's what I saw on one occasion. So that they couldn't print pamphlets. So these guys should lose, and they've made it easier for a judge who allows them to fill all available time and space with their bullshit. But he has also, correctly, on several occasions, cited the law that I think applies here, which if, say, McArdle, Wade's attorney, mistakenly released information he only got from his client in the attorney-client relationship, then that can't be used unless there's some exception, and there isn't one that I know of. And it couldn't be released to Trump's attorney, unrelated to the litigation of the divorce, unless Wade waived his right to keep it privileged. And when he had the chance on the witness stand, he said he didn't waive it. So that's my thinking about what's going on. I'm sorry I zeroed in on this, but it's such an interesting problem, and it's a problem throughout all the cases, in that lawyers take the immunity appeal to the Supreme Court. It's a bullshit appeal. Its only excuse is to spend time. We have had the D.C. Circuit give several versions of its opinion that the president doesn't have immunity. And the Supreme Court, if they sweat us out, it means they're making a political decision. They're not serving us as an impartial court on a very difficult and historic question. So I say goodbye to you for the day from my cathedral of trees, and I look forward to seeing you tomorrow. And I put together a roser, if you will, the sound of a quiet stream except for the running of water. All the best. Bye-bye.